7 months after the breakup, she opened her mailbox and found a letter demanding $30,000, or else. Not a text, not a phone call. A formal, professionally written legal letter giving her exactly 1 week to respond before her ex-fiancé would, quote, proceed with filing. The house she paid for with her own money, the career she built through years of hard work, the savings she accumulated while essentially bankrolling an entire relationship. All of it, suddenly, on the line. And the wildest part, he might actually have a case. Welcome back. Today we're diving into a story out of Washington State that is equal parts infuriating and genuinely important for anyone who has ever lived with a long-term partner outside of marriage. Because what happened to this woman could happen to you. And most people have absolutely no idea this legal exposure even exists. Let's set the scene. A woman in Washington State spent 7 years with a man she eventually got engaged to. 2 of those 7 years were spent engaged, but there were never any definitive plans to actually get married. No venue booked, no date set, no serious wedding planning underway. Just an engagement that sat there, floating, with no real destination. Throughout the relationship, she was the financial backbone. She had a stable career, a steady income, and a clear sense of direction. He, on the other hand, was perpetually financially unstable. She supported him while he pursued the dream of starting his own business, which she encouraged because she wanted to be a good partner. She wanted to see him succeed. She bought a house, with her own money, her name on the mortgage, her down payment, her financial risk. He moved in, and they built a life together, or at least, she built a life, and he lived inside it. The breakup happened about 7 months before this story picks up. And for those 7 months, she probably thought the hardest part was behind her. She was paying the mortgage on her own now, managing everything herself. Utilities, the alarm system, pet bills, insurance, all in her name, as it had always been. She was moving forward. Then the letter arrived. Her ex-fiancé had drafted, or more likely prompted ChatGPT to draft, a formal legal demand letter citing something called a committed intimate relationship, sometimes called a CIR, under Washington state law. And in that letter, he laid out exactly what he believed he was owed. $30,000, broken down with the kind of line item specificity that would almost be impressive if it weren't so enraging. Here's what he claimed. First, $10,000 representing what he called the equity portion of his mortgage contributions, his share of the principal that had been paid down during the time they lived together. Second, another $10,000 for what he described as the non-equity portion of those same mortgage contributions, essentially the interest and general cost of living payments he made over the years. Third, $5,000 for electrical work he paid to have installed in the garage so he could run his business out of the property. And fourth, a labor claim, 100 hours of landscaping work on her property, billed at $50 per hour, totaling $5,000, $30,000 in total, 1 week to respond, and a closing line offering to discuss settlement or mediation if she preferred to handle things quietly. She noted, not without some bitterness, that the letter conveniently omitted the $3,000 he still owed her from their time together. Now here is where this story gets legally interesting, and why every person watching this needs to pay attention. Washington State is one of a small number of jurisdictions in the United States that formally recognizes what is called a committed intimate relationship. This doctrine, sometimes called the meretricious relationship doctrine in older case law, holds that when 2 people live together in a stable, committed, marriage-like relationship over a significant period of time, courts may treat certain property they acquired during that relationship similarly to how marital property would be treated in a divorce. This is not the same as common law marriage. Washington does not recognize common law marriage. But the CIR doctrine is arguably something more targeted and in some ways more unpredictable, because the courts look at a totality of circumstances to determine whether the relationship qualifies. Factors typically include the length of the relationship, whether the couple lived together continuously, the nature of their commitment, whether they combined their finances, and how they held themselves out to the public. Whether friends and family saw them as a couple in a serious, committed sense, 7 years together, 2 years engaged, living in the same home. That checks a lot of those boxes. Now, does that mean he wins? Absolutely not. And this is where the details she shared start working in her favor. The house was purchased entirely with her funds. He contributed nothing to the down payment. The mortgage has always been in her name alone. They did not have joint bank accounts. He paid her rent, small, inconsistent, often split into multiple partial payments because he frequently didn't have enough money at one time. That is not the financial entanglement that courts typically look for when determining whether property should be divided as jointly acquired. The electrical work in the garage is perhaps his strongest individual claim because that was a direct financial contribution to an improvement on her property. And specifically, an improvement that benefited his business, not hers. $5,000 for a tangible, documented improvement might be the most legitimate piece of his demand, though even that is complicated by the fact that the improvement also benefited his own commercial operations while he was running a business from her home. The landscaping claim, 100 hours at $50 per hour, is where things get almost absurd. Couples do things for each other. They mow lawns, they plant gardens, they fix things, they help out. Courts are generally very reluctant to let one party retroactively bill the other for domestic labor or shared home improvement work that was done in the context of a loving relationship. Because if that standard were applied universally, every ex-partner in America would be sending invoices. The equity claim and the non-equity mortgage contribution claims are the most legally complex. His argument seems to be that because he was paying her money each month, even if irregularly, and even if she had to chase him for it, those payments constituted contributions to a shared asset, and he deserves some return on them. Whether a court would see those Venmo transfers as rent payments or as quasi-mortgage contributions is a genuinely contested question, and it would depend heavily on how those payments were characterized, documented, and discussed between them at the time. The good news is that she recognized immediately what needed to happen. She was already planning to call a lawyer the next morning. That is the right move. And here's why it matters even when you think the other person's claim is ridiculous. The law is not always about who is right. It is about who shows up prepared. If she ignores this letter and he actually files, she could find herself responding to a lawsuit from a disadvantaged position, with no strategy, no documentation organized, and no legal framework for countering his claims. If she engages a lawyer now, she can get an honest assessment of her actual exposure, understand which of his claims have any realistic merit, and either negotiate from a position of strength or prepare a defense that reflects the full financial picture, including the $3,000 he owes her. There is also a critical lesson here for anyone who is in or has been in a long-term relationship outside of marriage, particularly in Washington, Oregon, Alaska, or any other state that has adopted similar doctrines. If you own property and your partner moves in, document everything. Keep records of who paid what and in what capacity. If they are paying you rent, make sure that is clearly understood by both parties as rent, not as a contribution to shared ownership. If you make improvements to the property together, talk about the nature of those contributions before they happen, not after the relationship ends. If you are supporting a partner financially while they build a business, understand that there may be future legal implications to how that support is characterized. And if you receive a formal legal letter from an ex making financial demands, do not panic, but do not ignore it either. Get a lawyer. Even a single consultation can give you enormous clarity on where you actually stand. This woman's situation is stressful, it is infuriating, and it is genuinely unfair in the human sense of that word. But she is not without options. She has documentation, she has a clear record of property ownership, she has evidence of the financial imbalance in the relationship, and she has 7 months of evidence that she has been managing everything on her own. The law in Washington is complicated, but complicated is not the same as hopeless. If something like this has happened to you, a demand letter from an ex, a dispute over property or money after a breakup, or questions about your rights in a long-term relationship that wasn't a marriage, the most important thing you can do is get informed, before you respond. A family law attorney in your state can walk you through exactly what you're facing and what your realistic options are. Most offer initial consultations, and that one conversation could save you thousands of dollars and months of stress. If you found this video helpful, share it with someone who needs to hear it. And subscribe if you want to keep seeing stories like this one. Real legal situations, broken down so you actually understand what's at stake. We put out new videos every week, and trust us, the stories only get wilder from here.